invite to our next panel onto the stage, Professor Dr. Rangin P. Tripathi. Professor Dr. Aparna Chandra. Apurvanand. Nitya Riya Rajshekhar. And now I introduce the moderator of this session, Disha Chaudhary. She's a senior research associate at Center for Law and Policy Research and graduated from Lady Shri Ram College and Faculty of Law, University, Delhi. She also went to complete her LLM from Harvard Law School. Prior to CLPR, Disha worked at Center for Justice Law Society at Jindal Global Law College, where she was assistant director and also a teaching fellow from 2021 to 2023, and a clinical assistant professor from 2023 to 2024 with the Law and Marginalization Clinic. With that, over to you, Disha.
Thank you, Priya. I hope everyone's well caffeinated for a very exciting conversation we have ahead of us. So our second and concluding panel for today's evening is on data-driven law reform. So we're going to be talking about numbers and the stories those numbers tell us. Before I introduce our very exciting set of panelists, I'll just walk everyone through the structure of this conversation. So through this panel, what we're looking to do is really think through what systematic collection of data can do in terms of proposing systemic reforms to improve inclusion of women in the judiciary, and how disaggregated data collection may help in both increasing transparency and fairness, but also what some of the challenges may be to both collect this data, store it, and also sustainably use this data for long-term reform. For this panel, we have four very exciting panelists with us. First is Dr. Aparna Chandra, who is a professor at the National Law School of India University and specializes in constitutional law, human rights, gender, and the law and judicial process reform. Professor Chandra is the co-convener of the Indian Feminist Judgments Project and has authored books and articles focused on legal reform. Professor Chandra is also the co-author of Court on Trial, a data-driven account of the Supreme Court of India, which is a book that builds on over a decade of empirical research to offer data-driven suggestions to improve the effectiveness and integrity of the court. We also have Professor Rangin P. Tripathi, who is a professor of law at the National Law University of Odisha. A graduate of Utkal University, he's gone on to do an LLM from the National Law School of India, a PhD in law from NLUO, and then also a postdoctoral fellowship at Harvard Law School as a Fulbright scholar. Professor Tripathi is currently the director of the Center for Public Policy, Law and Good Governance, which has launched COJE, the Know Your High Court Judges project, which makes data set available on Justice Hub and is an open source data platform related to the Indian justice system. Our third panelist is Apurvanand, who is the head of data operations at Data for India, which is a public platform that uses data from the Indian government and international agencies to produce insights and charts on socio-economic issues. Before working for Data for India, Apurva was also the data lead at Civic Data Labs and has, in fact, previously also worked with COJE. And our fourth panelist is Nitya Riya Rajshekhar, who's a colleague at the Center for Law and Policy Research as a senior research associate. Nitya is a graduate of the West Bengal National University of Juridical Sciences and has gone on to complete her LLM from Columbia University as a human rights fellow. Nitya brings over 8 years of experience in litigation with focus on public interest litigation and human rights, and has previously also worked with Lawyers Collective and the chambers of Senior Advocate Jayana Kothari and Grover. At the Center for Law and Policy Research, Nitya has actually been leading some of the data research for this particular initiative and will be drawing on work from there. We'll start with Professor Aparna Chandra, will be speaking to us on data and gender and harnessing judicial data itself.
Thank you so much, and thank you for inviting me. I thought I could briefly touch on the importance of data for law reform, the challenges in working with courts and with legal institutions in gathering data, and then speak more specifically from my prior work on data around judicial appointments. The one reason why I at least got into looking at data and as a way of engaging with judicial and legal processes more broadly is the anchoring effect of data. When we have data and we have hard numbers to describe the described reality, it ends up anchoring conversations, which is both good and bad. But so many things that we think of now as the common sense has emerged because there's been some hard data that has been put to the question. So the idea that the Supreme Court today, for example, is broadly an appellate court and its constitutional function is declining, may have been known to insiders, but as being part of the general conversation of the legal profession and a general view of the court has become possible because of a whole generation of effort on around ascribing numbers to the work that the court is doing. So there is a very powerful anchoring effect that data has, and it can shape our sense of the reality, the sense that we make of the reality, the common sense of that, of the profession, in this case the legal profession, or the institutions that we are studying. And well done, it can give a more holistic picture of what's actually happening. A large part of decision-making and policy-making in India, and I don't mean only in the legal profession, but in India more broadly, is very anecdotal and impressionistic. I've had the privilege of working quite extensively with the Law Commission of India, and this is something that we were finding there as well, that many decisions that are made for law reform are made on anecdotal, impressionistic accounts of what might be happening in the world. And we know that these accounts obviously are incredibly subjective, and given the exclusion of diverse voices from these decision-making spaces, are likely to reflect a very partial reality, and a very partial reality of those who are already in power. So a holistic picture may be possible if we do data well, right, and in a more holistic way. And it can both confirm our intuitions about that reality or challenge our assumptions about that reality. So just to give you an example from judicial appointments. This is, I think, a fact figure that was discussed in the previous session as well. The data on judicial appointments in the lower judiciary shows that about 40% of judges in the lower judiciary, in the subordinate judiciary, are women. And that seems to suggest, and the Supreme Court has suggested in its State of the Judiciary report, that this indicates that there is a huge progressive upswing in diversity in the judiciary, and that it's a pipeline question. Over time, we'll sort out the diversity question in the higher judiciary. But if you actually break down this data, and I saw Shruti from Vidhi somewhere, I'm relying on their data here. If you break that data down and see where these 40% women are coming from, you see that only 20% of the district judges at the district judge cadre, at the higher cadre in the lower judiciary, are women. And only 11% are directly coming in after 7 years of work experience, right? So at least 7 years of work experience, which is very close to the percentage of women who are there in the High Court as well, right? So it's actually perhaps not the case that exams are better for women as compared to, networking. Perhaps that's the case as well. But there might be other factors. That 7-year work requirement may be something that is impacting women in a way that we need to really carefully study. It's a question, at least, that we need to ask. And that's a question we may have to ask. I mean, there's decision in the next few days. I think we'll have a decision from the Supreme Court on whether there should be a mandatory 3-year, practice requirement before someone is eligible to be appointed even to the entry-level judicial positions. And I think there are lessons to be learned from there. So data opens up these possibilities of looking at facts and figures in a new way. Similarly, for the longest time, when we've engaged with decision makers within the profession about the absence of diversity and gender diversity in leadership positions and in the higher judiciary, we've been told that this is a pipeline problem, right? That we don't have enough women entering, and that is why we don't have enough women at the top. As the pipeline sorts itself out, we'll have more women. Well, actually, the data does not bear this out. If you see the percentage of women who are in law schools across the country. And you see that not just at this snapshot, at this instance, but for the past 15, 20 years. And if you look at there's the AISHE reports, higher education reports, you'll see that about 32% of law students in the programs and graduating are women. The numbers drops drastically when it comes to the number of women who actually enroll in the bar, which is about 15%. 3.4% are senior advocates. 2% of state bar councils have women, none at the BCI, so on and so forth. So we see a very sharp decline. And the official story that the problem is about women entering the law may not be the case. Then if that is it's clearly a problem if it's only 32%, but it's not as acute a problem there as it is within the bar, right, in the enrollment to the bar. So the question is then structurally, what is it that is inhibiting women from entering the bar, and what are those structural interventions that can be made for law reform at that stage, right? So it allows us to ask very pointed questions. Having said that, data is also, of course, open to interpretation. And there is just like law, data is not objective. It is open to interpretation and misinterpretation and creative misinterpretation. And so any analysis or any inference drawing from data has to therefore be very carefully thought out. And unfortunately, one of the reasons why data plays such an anchoring effect and such a powerful catalyst in law reform conversations is because this myth of objectivity of data. So, but just to give you an example, I think this came up a little bit in the previous session as well. If you see a decline in the number of sexual harassment complaints, is that a good thing or a bad thing, right? Does that mean that sexual harassment is declining, or that sexual harassment complaints are declining? And you know that if you just look at the data without context and without having a theory that undergirds that inference, one can be misled very easily. Having said that, data gathering in India on the judiciary or on the legal profession is incredibly difficult. Our systems are not optimized for evidence-based decision making, and definitely therefore not for data-based decision making, which means that we don't gather data in a systematic way. So it's not as if courts are gathering data in a systematic way. It's not as if the legal profession is gathering data in a systematic way or storing it in a systematic way. So we've been filing RTI. So we have a parallel initiative, perhaps a sister initiative that's going on, where we're looking at where we are working with early career women lawyers in litigation, and we've been trying to get AIBE and certificate of practice data from across the country. And I mean, of course, we have to follow the RTI process because this data is not publicly available. To the extent that it is available, it is not disaggregated. It's aggregated data. It will give us data for, like, you know, the whole of Karnataka, but will not give us the kind of granular data with which we can make, run more sophisticated statistical tests on. So, and even when this data is available, very often it's available in physical forms, or you get a huge data dump that you don't know how to make do with. What that means is that very often we have to then go out and gather our own data. And that might mean, in this case, we are doing surveys because we're trying to get to women's experiences of the litigation profession. We are doing it through a survey form that's time intensive, that's money intensive, and it's difficult to sustain. So sustainability of data over time requires that the person who's generating the data is doing that data work, is maintaining that data, maintaining it in a robust, usable form, and that is publicly accessible, and that we don't have. So our forms collect a lot of data, right? But they collect it more as a matter of form rather than necessarily because there's some action oriented with that data. National level data work becomes incredibly difficult, of course, because we are a federal system. Being a federal system is not a bad thing, but that means that there are that many points of intervention that one has to make to get that holistic picture. And finally, just in terms of depending on what questions you're asking and what are the inferences that one is seeking to draw, there is a whole range of factors that need to go, a range of data points that one needs to be able to really study a phenomenon that one is studying. So look at diversity, right? We need robust demographic data. Now, clearly our courts are not in the business of collecting demographic data, even of the judges that they are appointing. Where does one, as an independent researcher, get that kind of demographic data? There is something that you can get from the profile of individual judges, but a robust sort of data that one can stand behind becomes difficult to get. And then if you want to draw an inference with respect to diversity, right? So for example, if I were to ask a question, does the Supreme Court prioritize excluded groups for appointment to the Supreme Court, right? Imagine if I was asking that question. I would need a level of granularity of data which is not sort of, isn't just about who this person is, what their gender is, what their caste is, but correlations, right? So is it, and particularly in the case of intersectional identities, what is it that is the driving factor, right? What are the drivers of this kind of an appointment? And that level of granularity, again, is something that has to be baked into the system. It cannot be ex post facto. It's very difficult. Not that it cannot be, but very difficult to uncover ex post. I know Rangin's done a lot of work in this respect. So, of course, it can be done, but it's very difficult to do. With that in mind, just to give some sort of initial or very brief statistics with respect to judicial appointments that we found in our work. So our work looked at data on Supreme Court appointments from 1950 to 2018, and then looked at all High Court appointments from the start of the collegium system, so 1993 to 2018. And interestingly, I mean, of course, we know the picture with respect to, the headline items of gender diversity and caste diversity, that it's pretty much, it is not diverse. But if you look at Supreme Court appointments, an interesting shift that happens after the collegium system is that the collegium is drawing from a very small pool of people. It is largely drawing from High Court Chief Justices. So 86% of all collegium appointments up to 2018 were collegium appointments to the Supreme Court were from High Court Chief Justices, as compared to only 53% in the years prior, from 1950 to 1993, when it was an executive appointment system. Now, what that means is that if you have, if that pipeline question is a live question, and you have a bulk of people coming from the lower judiciary, their ability to get to the Supreme Court is going to be very difficult. You're not going to be able to sort that problem at the Supreme Court level if things don't change, because the collegium has really contracted the kind of people that it is drawing into the Supreme Court. Interestingly, then one would think that if the Supreme Court were interested and Supreme Court judges were interested in getting in more judges into the higher judiciary and higher into the higher judiciary, they would then appoint more women as High Court judges. Only 12 out of the 242 judges that the collegium has appointed have been 12 out of the 242 High Court Chief Justices that the collegium has appointed have been women, right? Interestingly, though, women get appointed at a later age than their male counterparts. And of these, the women who make it to the Supreme Court have to be generally High Court Chief Justices of multiple High Courts before they get to the Supreme Court, as compared to their male colleagues. Now, the numbers are so small that we can't draw any statistical correlations, but it does point to something, right? It does point to the fact that in a seniority system, if women are elevated to the Supreme Court at 59.3 years versus men who are being elevated at 57.9 years, that just means that they're never going to get very high up in the system. Women are being appointed to high courts at a later age as compared to their male counterparts, which means that their ability to become chief justices and rise in that system is difficult. And that really points to the need for a very conscious intervention, right? A conscious diversity intervention. This cannot be sorted through a pipeline approach, right? That get in more women at the lower levels and the pipeline will take care of itself. The pipeline is broken. The pipeline is because of, and one can imagine what those reasons are. Women are coming in at a much later stage. Because women are coming in at a much later stage, they are not going to rise through the ranks if the surrounding conditions don't change. And so intervention in those surrounding conditions are particularly relevant if we want to see a greater representation of women in the higher echelons of the judiciary. I will stop with that and happy to take questions later.
Thank you so much, Professor Chandra. I think that segues very well into our next speaker's session, which is on data on gender and looking beyond the basic minimum. And Professor Tripathi has been doing some of this work on geographical diverse data and granularity. So I'll hand it over to you.
Thank you, Disha. Now, to just build on a point that Professor Panna made right now, that the collegium has significantly, shrunk the pool of candidates it selects the data for its judges from. It's not simply that now most of the Supreme Court judges are from amongst the chief justices. The fact of the matter is 43% of all high court judges appointed by the collegium come from the subordinate judiciary. But only 4% of those judges become chief justices. So in a career avenue which is significantly a bit more objective, a bit more regulated, where women have a chance of progress, the number of chief justices appointed from that pool is only 4%. So I completely concur with her when she says that this is not a pipeline problem, because the entry level of women at the bar, at the bench, at the judiciary is there, but there have been significant barriers which impede their progress to the higher positions. I'll just give an example from something that I'm working on right now, which is unpublished. So we are looking at impact of affirmative action in subordinate judiciary in increasing women representation in district judiciary. And we see that there's a positive correlation, that once you have an affirmative action scheme, more women get entry into the judiciary over a period of time. But what happens to them after that? So when we looked at Odisha, for example, we recognize that if you're a woman judge, if you're a judge, then having leadership positions in certain institutions like High Court Registry, Judicial Academy, the Law Department, or the state legal services authorities, these are very important signifiers of your future possibility of becoming a high court judge, because that's where you build your connections, that's where you build your familiarity with the system. Now, over a 12-year period from 2010 to 2022, out of 196 appointments made to these positions in Odisha, only 11 were women. And it's not because there are not sufficient number of women in those eligible cadres. This is a very conscious choice where women are not included in these leadership positions, which then subsequently impacts their capacity to be considered, right, for a judgeship. So it's not something that the High Court collegiums can wash their hands off, because they are the ones who are recommending who will become a High Court judge, and they are the ones who are deciding who gets to be considered for these positions in the first place. So if women judges do not have sufficient experience, 20 years into their service or 15 years into their service, in these important administrative positions, it's the same High Court which is responsible for it. So they're not in a position to assert that, we do not have enough women judges from the subordinate judiciary that we can recommend for High Court judgeship. Now, data, one of the things that I wanted to emphasize upon, which I was sharing with Professor Aparna and Apurva also earlier, is that we have a lot of descriptive data about what is the state of gender representation in judiciary, at the higher judiciary level also, at the lower judiciary level also. It follows a similar pattern about what is the number of women judges at a particular given point of time. That is, let's say today is 22nd March 2025. As of date, all over India, how many judges are women, High Court judges are women. Or we can do a time analysis also that, okay, in the last 20 years, since collegium came into existence, over the last 50 years, over the last 10 years, how many judges are women? That is one. Then we look at the tenure that they have, at what age they are being appointed, and how long they are serving in the judiciary. But for us to talk about data helping reform, data has to go beyond this. And it needs to enable us to do a couple of things. So I'll just give an example. I was just reading through the note that was there as a part of the sheet which was given to us, where there's an analysis of Justice Chandrachud's tenure as the Chief Justice of India, and how throughout his tenure, he has failed to appoint any women judge to the Supreme Court. My concern there is, why is this question being asked only about Chandrachud? Why not Justice Kaul? Why not Justice Ajay Rastogi? Why not Justice Joseph? Why not Abdul Nazir? Because when Chandrachud was the Chief Justice, all these judges served for a prolonged period as members of the collegium. And as members of the collegium, they have an influence, they have a stake in how the appointment process is happening. There is enough evidence, both anecdotal and official, which shows that it's not the Chief Justice is the sole driver of collegium appointments. Individual judges, when they can, when they want, they can control the agenda to a significant extent. The reason this is not happening is, we do not know who the collegium members are. Today I'm sitting in a room full of people who are very passionate about this particular subject, but I'm very sure if I were to ask that, can we say in 2005, who were the collegium members who appointed Justice Markandeya Katju to the Supreme Court? Barely any one of us will be able to say. Or Justice D.K. Jain. I'm just dropping names randomly, not with any specific. Yeah? But we'll be barely able to say, because we do not know who are the people who are making these decisions about appointments. When we say collegium, we are making these people invisible, who have decided things. The collegium is becoming a veil behind which actual decision makers, their legacy is rarely being questioned. So the first thing that we need, to continue on that thread, when we are talking about High Court judges, what's the point of blaming Chandrachud? Because Chandrachud can only consider recommendations which have been sent by High Court collegiums. So I'll just give you one small statistics here. From 1993 to 2021, collegium appointed in Odisha High Court 4% judges who are female. In Karnataka High Court, 6.2% judges, 6% judges who are female. In the last 4 years, Odisha appointed 0 judges. And Karnataka has appointed 1. Now we should ask this question to the Chief Justices and the collegium members in Odisha High Court and Karnataka High Court, that after 3 decades of track record where their female representation was less than 5 or just about 5, why in the last 4 years no judges have been recommended by them? So data needs to enable us to ask questions to the correct people who are responsible for these decisions that are being taken. We need publicly available record of which collegium appointed which judges, which collegium member was involved in which appointments, which collegium rejected which judges, how long was their tenure. And this data we need not simply at the Supreme Court level, we also need at the High Court level. So if data has to facilitate reform, it needs to enable us to ask questions to the right people. And then it also needs to help us ask better questions. And that we can do only when we know more about the selection process. For example, 2017 to 2019, we knew from each High Court what names were recommended. Not because the High Court collegiums shared that data, but because the Supreme Court collegium resolutions recorded that data. Since 2019, we do not have data available. We only have the final recommendation. It's just like a draft of a press release which will be eventually released by the government. Not simply that, collegium resolutions since then are not signed. The PDF uploaded in the Supreme Court website does not carry the name of judges who have resolved that particular decision. Now, I am at a loss to point out any other constitutional functionary, any other constitutional authority which can upload decisions, official decisions, without specifying which committee, which person. It's just a blank PDF document. What it does is that it stops us from analyzing, because the merit of an appointment can only be assessed when you can compare it with the merit of a candidate who has been rejected. Even when we are appointing MTA staff in our universities, we need to publish the list of shortlisted candidates. Then we need to upload the list of selected candidates, because that allows not simply the candidates, but for the public at large to be aware that, okay, if this person has been found better, better than whom? And that information needs to be available. And I understand that if they're not willing to share that information, then yes, even if we get anonymized information, that is better. But when we are talking about a normative standard of data that will help reform, we need to have information which is not anonymized. We need details just like we have for every other public office. Then we need more data on, and this is the last point that I will make at this point. Often our discussion on gender diversity stops at whether enough women have been appointed to the bench or not. We need also better data on what happens after they have been appointed to the bench. I'll give an example. The last time a female judge, being a member of the Supreme Court Collegium, was involved in the appointment of a Supreme Court judge was 2006, when Justice Ruma Pal was the second puisne judge and was involved in the appointment of Justice D.K. Jain, Justice Karjo, etc. So the fact that over a very long period of time, 4 women have only become members of the Collegium, and only 2 of them, Justice Manohar and Justice Ruma Pal, have been involved in the appointment of any other Supreme Court judge. Other 2 members retired without being involved in any appointment at all. And this is deliberate. We know this is deliberate because Mr. Gogoi has been very kind enough to record it in an autobiography, that when the Collegium is appointing judges, they're very conscious that if I appoint this person at this date, our current Chief Justice, very deliberate appointment, that we need to appoint him, and we need to appoint him now so that he will become a Chief Justice. It's recorded officially. So it's not that the Collegium is just looking at the best possible candidate and someone from amongst them gets to become a member of the Collegium, gets to become the Chief Justice. It doesn't happen like that. It happens very deliberately. So we need to have better data on what happens to women judges after they have been appointed to the bench. What kind of cases are being assigned to them? Are they being given administrative leadership positions? For example, I gave the example of district judiciary. The same thing applies to High Court also. There's a lot of administrative leadership which happens at the High Court level. Are women judges being given those positions or not? What kind of bench allocation is happening, right? Behavioral data during court proceedings. For example, in the US, they've been able to identify whether lawyers interrupt questions by female judges more often than by male judges. Right? Because one battle is to get enough women on the bench. But if we stop the battle only at that, we'll have the same problem which we're currently facing with the district judiciary. That we have a lot of women entering the workforce at the entry level, but because the post-appointment parity is not there, not enough of them are then subsequently rising to leadership positions. So for data to enable reform, true reform, it needs to enable us to do all these things. We get to ask questions to the right people who are responsible for the decisions. They cannot hide behind the cloak of a collegium, a council, a committee, anything like that. There have to be names. That so-and-so judge was involved in how many appointments? Why none of them were women? Another interesting fact, of the 2 judges, collegium members, female collegium members who were involved in the appointment of Supreme Court judges, none of them were involved in the appointment of another female judge. Justice Manohar and Justice Ruma Pal, they were never involved in the appointment of another female judge. In caste, it is different. Judges from marginalized caste, when they have been in the Supreme Court Collegium, they have been involved in the appointment of other marginalized caste judges. And we need to be able to ask better questions about the merit of the selection. Because if we only get to know who has appointed, without any data on how that selection has happened, it will not enable us to critique that selection at all. So I think I'll just take a pause here. Thank you.
Thank you so much, Professor Tripathi. I think just taking off what you said, that data enables us to ask better questions, and better questions require better data. So I'll hand it over to Apoorv, who will speak to us about the need for better quality data from the judiciary itself.
Thank you. Yeah, so we'll take a slight detour, mostly because of my limited understanding of the subject we are talking about in this conference. I'm coming, I'll try to add my experience of working with a lot of legal researchers for the past 5-6 years, scholars, practitioners, who are trying to work with data. I'm an engineer myself, so I'm not a lawyer. But what I want to question here and put a question to all of you, and when we are saying all this data is accessible, is it really accessible? So let me give you an example. So for the last 4-5 years, we are running this project called the Justice Hub. Now, what the Justice Hub is all about, it started as if some of you might have heard of this Harvard Dataverse and similar other projects. A lot of research happens outside academia. And what happens to the data when let's say a paper is published, or let's say a platform is developed, but what happens to the data? Usually it sits within some laptop somewhere and it gets lost. Or let's say someone files a bunch of RTI applications, they conduct their research, they write a few media reports, but then what happens to the data collected from this? So the idea was to, we knew a few people who were doing this, so can we request them to share something publicly, because it is supposed to be public, and can we in this way create a good corpus of good quality data sets? Now, I was in touch with a lot of people, and apparently everyone had some data or the other, but in a way, let's say they were Excel files which are not very formatted, and there were a bunch of issues. People were not confident sharing their data, and these are the various reasons. Now, a few good projects which also came out. I'll give you a few examples if you know. There was this project called the Zombie Tracker, which was created by this organization called Internet Freedom Foundation. They relied on the data by e-courts. Then Project 39A collects data from courts to write about death penalty. Then I think a couple of years back, the team at Article 14, they curated a bunch of cases from courts to research about sedition. They created a platform which is out there. So these are a bunch of examples. Imagine such a vast country. If I personally have spoken to a lot of people in this domain. So, so I personally feel, and every project, how the journey is, you start with let's say, and I was involved in some capacity in all of these projects. I'll give you an example of how the journey starts and how it unfolds. So let's say the first thing, okay, I want to collect data of Section 66A under the Information Technology Act. Why? Because that has been declared unconstitutional, but IFF being the work, given the kind of work they do, people were calling them that an FIR has been filed against me under Section 66A. But that is unconstitutional. So that was the trigger. Oh, now, okay, which means that something is happening in the country. So how do you start? Okay, let's see if we can find some cases in courts. FIRs mostly are not public. In some states they are, but let's forget about the FIR for now. Now let's say we do this pilot analysis for 10 or 11 states. First we go to NCRB. NCRB we check, okay, are there any cases there? Obviously, NCRB also it's not very disaggregated, but you try to analyze, okay, what are the states you should focus this analysis on? Because this is IT Act, let's focus on the metros. Maybe more people are, using social media there, and that's why this is happening. So you select a bunch of states, and then you go to e-codes. Now, once you go to e-codes, then it's a whole journey. So first step is, okay, how do you get this data? Professor Aparna said that it's one of the most difficult fields to conduct research in, and also it's the most expensive. Even climate research today, there are good data sets available. But when it comes to legal research, what happens is it's a very, especially quantitative legal research, it's a very interdisciplinary field. I've been also talking to a lot of people, students, faculty members within academia, and not a lot of, maybe a lot of research is happening there, but a lot of research also happens outside academia, where let's say you're working with a statistician or data scientist, you have a lawyer, you have a legal researcher, so it's a very interdisciplinary field. So then, if it takes 6 to 8 months just to get data, clean that data, start that analysis, suppose you get a grant, and you have a 1-year grant to conduct this analysis, 8 months goes into cleaning the data, so then will you say that the data is really accessible? And this is one common story which has happened across all the projects which I have mentioned, and it still continues to this date. We've also spoken to the E-Committee of the Supreme Court. They have built good platforms. One of them is the NJDG. But somehow, now the NJDG, I think in the last panel discussion, someone said that it's anonymized. It's not anonymized, it's aggregated. But even, let's say, though it's aggregated, if you have to do something with that data, you will need to fetch that data outside the platform and bring it to your laptop, do whatever you want to do with it. That process is really difficult. I use a technical term here, API, which means just a way to get information. So then none of those are available for any of the platforms here. What people end up doing is they will scrape data, or it's a way to pull data from a website. But if you speak to a lawyer or if you speak to someone, then people will say that this is illegal. So what is legal, what is illegal? Data is available, not available. If it's available, it's not very well documented. So I personally feel legal data is not accessible most of the cases, especially when it comes to district courts, it is not accessible. Now, the other thing here is, what do we do about this? So I also feel it's not a lot of people are working, especially if I speak to a lawyer or someone who is not from, let's say, does not work with technology in any way or form. The first thing is, though there is curiosity to do, but when it comes to engaging with data, then it's like, oh, there's some fear or something that, no, this is not something that I want to do, or I can do, or I can engage with, which means that suddenly the demand drops. And if the demand drops, if you are not requesting a lot of data, then obviously 2012 or 2013 was when e-courts was launched. Obviously, if you look at the data from 2012, you compare it to the last year, the quality has improved, but not what it should be at this stage. It's some more way, I personally feel if we can create more demand, then it will in some way or form help the overall quality of the data as well. One thing to people sitting here, nowadays we have something, I think all of you know about ChatGPT, Claude, and these large language models. Whatever you feel about these, ethical, non-ethical, useful, not useful, one thing to think about is this had really made possible for I personally feel, and this is something which I have experienced also, if I'm working with a lawyer and they are using, let's say, either of these models to work on a data set, their productivity has just improved massively, which means that I can't write that prompt. Let's say what Rangin sir was just telling about, okay, if you have the data, these are the things you have to analyze. Now, an engineer won't be able to write that prompt, but a lawyer will, because of their understanding of the data, their understanding of the field. So they will be able to do a lot more with data. So I think this is one thing that we should also test and keep promoting if you are working with students, or if you are working with other researchers, that let's use these tools and see what is the max we can do with it. And I personally feel that overall productivity has improved a lot in terms of, let's say if I give you an Excel file, or if you start with this hypothesis, okay, I want to know how many cases under 66A has been registered in Delhi and what has happened to all of these cases. Now you go to a course, you will take 2 months to download the data, clean it, do that. But now there is this one data set which was published by this organization called Development Data Lab. It was, I think, last I checked, it was available till 2018, but they are also planning to update it. So it has 80 million cases, out of which I think 10 to 12 million are criminal cases. Just suppose you have this data set, which is, you can just now go and download that data set, maybe figure out a way to upload it to an LLM or do something about it, and then ask these questions. You don't have to clean the data, you don't have to do anything. See, I'm not saying this will be 100% accurate and you will not publish the results, but this is just made it possible to do all this in the least amount of time. So, which was really hard a couple of months back. Yeah, I think overall these are my points in terms of, I personally feel it is not yet accessible, but now we have ways to start working with data. Yeah.
Thank you so much, Apoorv. I think I'll go directly to Nitya, who will be talking to us about some of the data that has been collected by CLPR and the gender gap in the higher judiciary.
Hi, everyone. So, I mean, as we all know today, and the whole reason we're here is because there is a gender gap in the higher judiciary, and we know there are fewer numbers of women. But the data that we have collected over the last few months, and some of it, you know, I really have to thank Aparna and Rangan especially, because your work was so critical as a starting point for us when we started this work. But some of the data which we've collected right up till the end of 2024 and even today verifies the fact that things have not improved since your study in 2018. And I just want to give an overview of these numbers currently. So in the Supreme Court, we only have 6% of judges currently. That's 2 women judges out of 33. And in the high courts, it's 14%. And since 2021, 23 appointments have been made in the Supreme Court. That is, over 2/3 of the court has been reconstituted, and not a single appointment has been a woman. So you've had 2/3 of the court being filled up with no women appointees since Justice Nagaratna, Bila Trivedi, and Justice Hema Kohli. In the lower judiciary, as has been mentioned, the numbers are better in terms of representation of women. It's 32% as of 2022. And surprisingly, when you look at the representation of judges elevated from the bench in India, men versus women, women make up 27.6% of high court judges elevated from the bench. So roughly those numbers are translating, like with 32% women in the lower judiciary to 27% in the higher judiciary. But there's clearly still a steep drop-off, and that is coming from elevations from the bar, that is from women lawyers. Not many people are aware that there is a 2:1 norm. It's kind of an unsaid norm which most courts follow, where for every 2 judges elevated from the bar, you elevate 1 from the bench. So roughly you would expect about 66% of all judges in the higher judiciary to be from the bar. And this is largely followed. If you look at the current numbers today, it's about 68% of all judges are from the bar and the rest are from the bench. But this isn't the case with women. So with women judges, the current breakup is, out of women judges from the bar make up only 11% of all judges elevated from the bar. And 11% is a number which is even lower than the overall representation of women lawyers, which Aparna raised earlier, which was at 15%. I mean, ultimately, what are we aiming for in terms of gender diversity for the judiciary, and why we're asking these questions is that if you have a constitutional democracy where you have a population of women which is 48.5%, no matter the actual numbers of lawyers or judges in absolute numbers, the representation at the levels of the higher judiciary ought to be counted against the population of the country and not necessarily the numbers of lawyers or the judicial officers present. Of course, there are many other barriers which women lawyers face as they enter through the profession and as they attempt to thrive in the legal profession. There's a lot of discrimination and stereotyping which they face, which leads to poorer visibility. And this is one of the factors which contributes to them being appointed at a later date. But the data itself on the appointments, of the age of women's appointments and their tenure, definitely points to a trend that when the collegium is considering these names, there is some sort of bias to appoint women at a later age, no matter what their qualifications are. So for example, even today, the average tenure of a Supreme Court woman judge is 4.4 years, as against 5.45 years for male judges. So it's just a 1-year age difference, but when you look at Supreme Court tenures, which are roughly only 5 years, 1 year is a huge mark. And as Rangan mentioned, only 2 judges have made it to the collegium in a decision-making capacity. 4 judges have been part of it, but only 2 have made decisions. And it's also why we've never had a woman Chief Justice of India. Justice Nagaratna will only be Chief Justice in 2027 for a total span of 36 days. So you question why she couldn't have been appointed earlier. Justice Indu Malhotra, who is the only woman who has been elevated directly from the bar, she has the second shortest tenure of any judge appointed in the collegium system. She had a tenure of just 2.8 years, which you would wonder, since it's a direct elevation, she ought to have been at the Supreme Court for a much longer period. The difference in the high courts is similar. There's an age gap there as well of about 1.8 years, which impacts seniority to reach the high court collegiums and to reach CJ positions in the high court. Speaking of chief justices, in the 25 high courts which we have across the country, 11 have never had a chief justice, and 15 courts have never had a woman acting chief justice, which means there's never been a senior-most woman in 15 courts in the entire country. And of course, we're just scratching the surface with this data. This data is only what's been made available through public sources, through High Court and Supreme Court websites. It's, as Aparna and Rangan and Apurv mentioned, there is potential for so much more qualitative data analysis and to be able to think of more, ask more nuanced questions and get more nuanced answers, which would help towards law reform. But just looking at the data which we have right now, itself is, we feel, is a reminder that the appointment system needs some sort of challenge, whether that's through, if we're asking the question of looking at minimum eligibility criteria, or if we're asking for different considerations for women or other minorities. These are some of the questions which we at CLPR are right now asking ourselves as we go through this data and as we're talking to people about what are the kinds of reforms which are available to us and what the feasibility of these actions are. I mean, the last major judicial reform effort was the NJAC, and the 4th judge's case held it unconstitutional. But the NJAC didn't touch on gender diversity or any other form of diversity. And in that case, the Supreme Court itself acknowledged the need for reforming the collegium process. They spoke about introducing minimum eligibility criteria for appointments. They spoke about greater transparency. And they asked the government, the executive, to formulate a new memorandum of practice, which till date, there has been no new memorandum of practice to decide to amend the collegium system in any way. So I think these are like, to measure the feasibility of these options, and even things like constitutional law reform, keeping in mind that there is a current private member's bill which has been introduced by a Tamil Nadu MP to amending the constitution to say that the judges from the higher judiciary should reflect the population of the country in terms of gender and caste. So that's a bill which was introduced in January, and we need to see where that will go and see what efforts, other similar efforts are possible. So I just wanted to raise some of these questions that we're considering right now.
Thank you, Nitya. I think there's been a lot of information sharing, so we'll open it up to the audience for questions, so there's more time to take more questions.
Questions? Yeah. Just introduce yourself.
Hi, my name is Ankita. I'm from the Migration and Asylum Project. I'm a lawyer by training. I wanted to ask that while I completely understand the pipeline problem and like there's been a great articulation around it today, the fact remains that whether it's that not enough women are available, or on the other side that women are trying so hard to succeed in a system that was not built for them, both these narratives are anecdotal, so to say, because even though we have the numbers for like what the dropout has been from law schools all the way to senior counsels or judges, we don't have, say for instance, how many people register and how many drop out. And it's not possible to track as well, because you could register at one place, practice at some other place, and drop out at some other place. Like, there's no way to track, there's no mechanisms that exist. I wanted to hear your thoughts about, because this, is it because that this pipeline argument has always been driven so much by anecdotal evidence that we have, as a system, built some sort of resistance against actual good quality or good quantitative data to drive these narratives, that we don't have systems around it at all, in spite of like so many attempts and so many different, like for instance, practice certificates and everything being issued. We've not built a system because we've gotten comfortable and we don't want to move towards something that is going to give that sort of data, and we want it, like evidence-based system is not, simply not the focus, and therefore not something that is being worked on.
Any other question? But since you've asked, I'll take maybe one or two new other hands who may want to raise. Yeah, then let me request the panel to answer, and then I'll come to the next question.
On the pipeline question, I think now with the COP, the Certificate of Practice Data, and for those of you who may not be aware, in 2010, the Bar Council introduced the All India Bar exam, that everyone who wants to enter into the litigation profession, definitely wants to litigate before courts, has to take that bar exam and then technically renew their certificate every 5 years. They also did a quote-unquote clean-up exercise, where for people who were who had enrolled in the bar before 2010 were supposed to then give proof of continuous practice and get their certificate of practice. Now, if this data were available, we would get a lot of data. And in fact, I mean, they publicly they release these statements, right? But obviously, attributing genders to names is a very fraught exercise, and I know other similar exercises in other contexts have done some level of attribution, but it's difficult to do that, particularly also because you might have surnames, you might have initials and things like that. Anyway, so on the question of, is it that we become so comfortable with some narratives that we don't track data? I mean, I think it's just a broader culture of absence of evidence-based decision-making, which also tracks to a broader culture of lack of accountability for decisions, right? Why am I deciding the way I'm deciding? How much do I need to justify? With what level of rigor do I need to justify my decisions as any organ of the state, right? I think that's a broader question that's not just targeted at the judiciary, even at the legislature. I mean, if you look at legislative deliberations and the quality of legislative deliberations, let alone executive fiats of the various sorts that we get, and again, let alone constitutional court judgments in our courts, we see that there is a lack of very rigorous sort of justification, right? And data really is part of that. So if you look at in the history of ideas, if you look at the move towards quantitative data and empirical studies of this sort, in policy making, it is coming alongside greater efforts at transparency, greater efforts at accountability, greater efforts at justificatory reason as being the highlight of how we hold our democratic system, how we work a democratic system, how we ensure accountability, right? So reason-based accountability and justification-based accountability, not just electoral accountability. So there's a large part of that here. I wouldn't, therefore, put all of that burden on just the presence of narratives. Definitely, this is not a problem that has been recognized as a problem by those who are within the system, right? The narrative helps in that. The narrative helps in saying, yes, there is a diversity issue, but the diversity issue is just a question of time. Pipeline will sort it out, so we don't need to be actively taking ownership of this problem and sorting it out. Right? And just to relate this back to what was happening in the previous session, perhaps this is where the bar associations can really push the state bar councils and the Bar Council of India, as well as the judiciary, to release data, right? Even if it is aggregated data. I mean, in the absence of aggregated data is better than no data, and anonymized data is better than, again, no data. So to push for data, to push for not just giving out the facts and figures as of today, but also to regularly capture and to regularly update those systems and that data, that takes care of the expense problem, that takes care of the inaccessibility problem. I mean, to the extent that that data is reliable, it will tell us something.
Yeah. Anybody wants to add? Then can I take the next question? Yeah?
Hi guys, I'm Vakasha. I work with a company called Logically. I'm also going to be here for tomorrow's session. I'm actually going to do a little bit of cheating and try and get an answer for one of the things which I wanted to address for tomorrow, which is, we had Justice Chandrachud, which came up here, the question of when he was asked why didn't you appoint any women judges during his 2-year tenure, he said that, there were no women senior enough for me to appoint that. So, one, given the data sets you guys have, is that actually true? Is it partially true? Remotely something which, obviously, because if it is true, then there are bigger picture questions, which of course would then mean that did he take steps to try to improve that by appointing more women to the high courts? Which, from what I believe, from what I know, he didn't really change the statistics on that either. But yeah, just if that's something which you guys can maybe answer that. I think the second question which I'd have, which again for anyone here on the panel would be, in terms of high court trends, because Supreme Court is particularly bad, but high court trends, have we seen any improvement? Because from what again we heard right now from the panel, you're saying that there were actually courts where they already had low numbers and now they have 0. So right now in this terms of pure state of data, where are we? What are the high court trends for appointments as a percentage looking like? Are they going up, going down, plateauing? What's happening there?
And sorry, there was one hand raised there. If I can just.
I'm from Vimochana. We are a women's organization, one of the oldest organization. And we have been working, and we need to knock the door of the justice courts and all. And all these 40 years experiences has been extremely, very negative, extremely negative. And now that I'm sitting and listening, there's so much that we need to work together. From the statistics of the women's movement in India, who spoke of nothing. There was no word called gender. When we started maybe 50, 60 years back, that particular word didn't. But it was the same thing what we are talking now. That's so much so that data matters. Yes, as you said, Dr. Apurva, it does, because in our kind of unnatural deaths, which we started as dowry deaths, we used to have 1,000 plus in a year. when the police files will show 400. So the data matter, not that we have been given any recognition anywhere, but it has brought the women's movement to this extent. And now that for the last 30 years that we started working on alternate codes, which Corinne has started, codes of women, where we have a very different kind of a way where this person, there's no evidence, there is no this kind of other things, entirely different which Jaina knows. I would really love to share those things, and I think we need to work and we need to give our experiences of what's really happening to the courts. Nobody knows what's 498A when the lawyers are suggesting, and that's what the woman is fixed. All that she wants is a husband back with no violence. But it doesn't happen. So once you are striving for the same thing, we are working for the same thing, but still we are so much apart. So I think the need, sitting at the second session, I feel the more and more need to come closer together. Thank you.
On the High Court front, a couple of things. So firstly, as I was trying to say earlier, that for who gets to be a High Court judge, I think the primary responsibility does not lie with the Chief Justice of India or the Supreme Court Collegium. It lies with the High Court Collegium and the High Court Chief Justice. So because it's something like the US system, where the Senate can decide who, can reject a candidate, but cannot select a candidate. And whatever research that I had done over this, when we had the data available for this, I had found that the rate at which High Court Collegiums are recommending women candidates, the Supreme Court Collegium is accepting women candidates right about the same rate. So it's not that, the problem, at least in the limited data set that I had, the problem was with the High Court Collegium recommending less women, not with the Supreme Court Collegium accepting less women. So that was the thing. And we did Khoj in 2021. For those of you who might not have heard about this, it stands for Know Your High Court Judges, right? Where we collected variable about High Court judges across 43 parameters from publicly and officially available sources for all High Court judges appointed by the Collegium till 2021. So to answer the question that you asked about whether something has changed or not. So now we are working on the Khoj 2.0, and this data is not yet public, but from what I can tell you from the data that I have at this point is nothing has changed significantly. There might be, a couple of high courts where there is a variation of 1 or 2 percentage points, but nothing which would suggest that High Court Collegium are cognizant of their responsibility to proactively address this issue, right? So there is no conscious effort, there is no conscious strategy on the part of High Court Collegiums, which is evidenced in terms of the appointments made, that they're looking to increase gender diversity. So across different high courts, for example, the data that I have here, sorry. Yeah. So for example, in Karnataka, from 6.2 to it has become 7.9 or something. But in Odisha, it has regressed from 4.2 to 3.4. So, but the changes are so minor that they are not reflective of any conscious strategy. It's just incidental that some high courts have, in this particular phase, some more appointments or some less appointments. So, yeah.
And just on the question of conscious strategy and the absence thereof in this case, I mean, if you look at where there is a conscious strategy, it's on regional diversity, where at least at the Supreme Court level, they still do a good job of regional diversity. Used to be the case, religious diversity. I haven't tracked it since 2018, so I don't know where things are on that. But there was a conscious strategy articulated both in judicial dicta in the judges' cases, but also if you spoke to judges and you saw the specific way in which in which people were being brought into the High Courts and the Supreme Court. There were, and in fact on regional diversity, even today, the press release, there was unsigned collegium recommendations, mention regional diversity as a reason why a particular person is seen as a suitable candidate. So there's a conscious strategy. And that goes to the point that there's no ownership there's no recognition of this as a problem for which someone has to take ownership.
If I could just add a point there, just to exemplify, when Justice Prashant Mishra was appointed to the Supreme Court, the collegium made a point of noting that from his parent High Court, that is Chhattisgarh, there has been no Supreme Court judge. So they're very conscious about the fact that they need to provide a better regional balance.
Yeah, I just wanted to add to your first question, Vakasha, on the justification of whether there are enough women in the pool of High Court judges for elevation to the Supreme Court. I would say yes, because, and also when you look at elevation to the Supreme Court from the High Court, it's not only seniority. There are many times that the collegium goes beyond seniority to fill up regional diversity and issues like this. Yes, exactly. So the chief judge, the High Court judge can be seniority 70 or 100 or 2 to get elevated to the Supreme Court.
Can I ask one question, one last question to Professor Rangin Tripathi? Just, you said data helps us ask better questions, yes. And you said, why should we not ask questions of the collegium, all the collegium members, and also the High Court collegium members individually? It's not just the Chief Justice, yes. But my question to you is, what is the, we know that the tenure of people on the collegium is quite fleeting. They may be there for very brief time periods, and then they retire. So is there really a merit, apart from naming and shaming, yes, sometimes that naming and shaming can be useful, but by the time you name and shame, that person has retired. And so there can be nothing much done beyond just saying call also didn't put, for example, any women's names or rejected women's names or didn't give reasons. Should we not be asking actually questions of systemic reform? Why is it, isn't it more important that instead of naming a particular judge, because we see that the effect is actually uniform across the board, So should we not be asking questions to make the judiciary accountable or the entire system accountable rather than individuals?
Thank you. So the point that I'm trying to make, perhaps I was not able to articulate it as well earlier, that if we are asking Justice Chandrachud, we should not ask only Justice Chandrachud. That doesn't mean that we should not ask questions of the system. That does not mean that we should not try to, talk about institutional reforms which are not personalized, which are depersonalized. But the broader point is that collegium members exercise power. They block appointments. They also push for appointments. And when we centralize that power with a single individual, it allows all other functionaries to exercise that power away, as I said, behind a veil, which according to me is not ideal. So I was talking about that point, that if we are asking Justice Chandrachud this question, that during your tenure as a Chief Justice or head of the collegium, how many women judges did you appoint? Justice Joseph should not be spared that question. Because at the end of the day, it's not as much about naming and shaming. When anybody is aware that their actions in a particular capacity is open to scrutiny, that something might be written either today or tomorrow, there is a possibility of them taking that work a bit more seriously or being more conscious about the kind of decisions they're making. Currently, what is happening is that although there are more than one persons responsible for judicial appointments in the country, the focus is only on one person, or the Chief Justice of India. It allows every other person to exercise that power in secrecy, without fear of their legacy being questioned. Justice Chandrachud's legacy is in question because of the perceived gap between some of the rhetoric and the conduct. Right? That fear of that legacy being questioned should be with everybody who is exercising similar power. And that's the point I was trying to make when I said that if we are asking Justice Chandrachud, we should ask that question of others as well.
If there are no other questions, I'll just close. So thank you so much, Professor Chandra, Professor Tripathi, Apurv, and Nitya. I think when we think about harnessing the power of data, you've raised some important questions, which I'll sum up. One is, what is the quality and granularity of data we need to be able to drive reforms and really ask the difficult questions? How do we think about accountability? Is it institutional? Is it individual decision makers? What are the challenges that demographic data collection poses, both logistical and ethical? And how do we sustain periodic data collection, both for time efficiency and resource optimization? So I think these are very informative questions that we can also think about when going forward.